Hello everyone, welcome to Tony Talks. To all our beautiful subscribers, we say thank you so much for staying with us. And if you're new here, we are happy you find us. Please don't forget to like, subscribe, and hit on that notification button so that you will be notified for more upcoming videos. In the comment section, please no derogatory comment. Thank you for watching. Till I'll see you in my next video. Stay safe, stay blessed. I love you. Bye.
Or not, through the DNA, through the birth certificate, through acknowledgement, that is pronouncement of the father that this is my child. Maybe when the person is alive, he has said, this is my child, and he has treated the person as his child, and the person bears his name. And there was no form of dispute while he was alive. And you can't come and say he's no more. Because the father, while alive, has claimed that the child is his or a child or not. Now, birth certificate is given when you have an international passport, marriage certificate, all those are legal tender that without anybody going to look at your DNA, going to go and bring your grandparents, go and bring them to come and acknowledge and all that, that is an evidence that you put directly, as long as it is an authorized document of the state. You understand? However, like you said, things can always be challenged in court. They can be challenged in court. If, for example, Baba Mohbad came through the route to say, oh, Wumi, this Liam is not our child. And Wumi says yes. And Baba said, let me see the birth certificate. He made a demand. And Wumi say, we didn't get any birth certificate while he was alive. The man that can challenge it through that, but you need to have, which means the father never acknowledged it in a way legally. Or Wumi comes and say, wait, I'm giving you ways, so I'm not being authoritative here. I said, based on that, if such thing happen. And Wumi comes and say, while he was alive, I have a video where he said, oh, my son Liam, in whom I am well pleased. That itself can suffice to say that he has made pronouncement that the boy is his son, if that evidence is available. You understand? But when it comes to going to court to slug out issues, like I've always said, and we've always debated on this paternity of Liam here and there, I've always said this matter must be, once there is a dispute on a matter and it is not resolved individually, gentlemanly, if it is taken to court, the court now has the power to put finality on it. Now, let us go back to this case of Liam. There is no precedence in this matter. The announcement of the court was as a result of an agreement from the party. This matter has not gone to trial. If the matter had gone to trial and they've argued front and back, and at the end of the day, the court now say, this is my ruling, this is my judgment, and it is accepted, that becomes a precedent because it's a ruling of the court. But in this, it was Wumi that finally say, I agree, let's do it. So the court is yet to go to the nitty-gritty of the matter, and the court has not, and because of what has happened, it has not even helped us to lay to rest if a grandfather has the legal right to challenge this thing, because it will still be a debate. That isn't a precedent, like you will say, oh, there is a judgment from a high court that says this, or there is a judgment that I referred to the other time that a child was born out of wedlock, and the family or the executor was saying, oh, it's not our child, and they could see that the child, they all acknowledged that it was born out of wedlock, but they were claiming that, oh, the mother was not married to him while he was alive, so the child does not have right to the man's inheritance. A Supreme Court pronounced that under Nigerian Constitution, nobody can be deprived because the child never begged to be battered. But it is acknowledged that the child has been born by this man, so he has legal rights to his estate, whether the mother is married or not. And that matter has been laid to rest. That is a precedent. That is a judicial precedent. Because there is a judicial pronouncement and it is seen to be. There is a ruling, a document that explained why they arrived at that judgment. But in this of Wunmi and Baba Mohbad, it was Wunmi during the proceeding that I agree, let us go and do the DNA. So this has not, if there is a matter that will come up like this tomorrow, they will still go to court until a court makes a proper pronouncement. Then you can refer to it. Judicial precedent is like you carrying your Bible and saying from Acts of Apostles, chapter 1, verse 2, it is a laid down law that it is seen that a matter of this magnitude have been debated for earlier and it has been ruled by a court. However, if the matter has been appealed against, we will then be looking at the finality of the court, which is possibly the last court those people went to, or through the Supreme Court, which is the higher court of the land. And that is why in legal matters, people usually use Supreme Court judgment as judicial precedent because you can't challenge it again. And a case that have lapsed when in terms of looking at the period of appeal and it was not appealed, then it is seemed that a judgment have been passed. But we cannot say, it would be wrong for us to say that Wunmi accepting to do the DNA is a judicial precedent. It is not a judicial precedent. It is an agreement of the party to say, we don't want to go further with the hearing, let us go and do the test anyway. It's not a judicial precedence.
Now, aristocrats, that is the point I was trying to clarify Aparano and the baby lawyer on. Because their assumption to it was that, the judgment is a legal precedent, that it constitutes legal precedent. And I'm telling them that no, it doesn't. It's only binding in that current case. And remember, that particular case did not undergo trial. So how will it stand? How will it stand the legal precedent?
It did not. It's like you went to court and before it gets to trial, the two of you agreed.
So how is it going to be binding in other case?
See, so when they it's come like a case of myself and you go to police station with a fight. I will come tell police. Police, we don't settle. We know they fight again. Then police not get wahala again. They carry your wahala, they go. It is not that police have sat on the matter and have resolved. Police did not resolve. You resolve it on your own.
Oh so yeah, baby lawyer.
It will like that.
Tomorrow, baby lawyer, come and hear it too.
A matter like this can go to court, and it will be seen as fresh because it is only the ruling of this one of them doing the test. It is limited to this case alone. That is how they want to resolve it. But to use it as a reference for other cases, it must pass through the proceedings of a regular court where you have trial, you have everything, and you now read a ruling. And that
exactly. The court must have to pass judgment based on the trial. You get me? So in that particular essence, people calling the judgment a precedent, legal precedent, that is totally wrong because it is not binding in a future case in any judicial process, but that particular case.
Yeah, so it's only restricted to this very case for now.
Exactly.
And now the thing where they pay me for this matter, they say, assuming this matter went through trial, it will lay to rest the right of a grandfather to demand for such thing.
That is my point.
Because that would be a judicial precedent.
People will be able to understand the interpretation of the law and how they concluded that particular case scenario. If he had that ground to actually get the order to be determined by court process and all those things. Because
you would just tell the party. If we go to court, we are wasting our time. Because the judge will tell you are wasting the time of the court. Because there is a precedence on this matter,
already and it has been laid and that precedent must be binding. If it's a similar case.
Yeah, it will tell you refer to it. Why carry your wallet when something of that has been done?
They try to educate these people since headache don't they catch me. I try. Thank you. At least now all of them don't mute. But if I'm talking now, they'll be like, because of his Wumi, because of the Wumi. Listen and learn. Nobody should be ignorant of these laws.
Top movie, how are you?
I'm all right.
Wait, please. Let me quickly. Come on, what are you saying? You are very wrong. You are very 100% wrong. What are you saying?
Aristocrats.
Wait. No. Let me ask you my question. Does Mohbad have the right to request for DNA?
I have already told you, anybody has the right to request for a DNA.
No, that is not my question. That is not my I didn't ask, does anybody have the right? Does Mohbad father has the right to request for DNA?
He has the right, but to grant him, no. He doesn't have that
my question. That is not don't explain to me. No. That is not, don't explain. Does Mohbad has the right
to request for DNA? He has the right to ask.
Oh my God.
He has the right to ask. But he doesn't have the legal ground for that DNA to be granted.
Now, does Mohbad? No, just wait. Don't play games here. The Aristoca did not help you at all. You are in the same problem. No. Listen. You are wrong. You are very 100% wrong. Okay.
Shoot your shots.
Does Mohbad has a legal ground to ask for DNA of baby Leon? It's like you're not understanding the English you're using yourself.
Go ahead, Papa.
No, same question. No. Does Mohbad have the legal ground to ask for DNA of baby Liam?
Exactly. He has the ground. He has the legal right to ask.
Yes, he has a legal right to ask for the DNA of baby Liam, right?
As well as even me, so I have the legal right
not my question. You see, okay, just go on with Aristocrat. I think you like people who just listen to whatever you say.
I don't want people to misunderstand
you are very wrong.
me.
You are 1,000% wrong. You are 1,000% wrong.
Go ahead. Go ahead.
Now, does Mohbad have the right, the legal right to ask for the DNA of baby Liam?
Yes, he has.
Okay. Now, does anybody, or do we have any judicial precedence of this case in the Nigerian history before, where a grandfather has requested for the DNA of a child before in Nigeria? That's my question.
Come again.
Do we have any judicial precedence in the Federal Republic of Nigeria where a grandfather has requested for the DNA of a grandchild and it has not been granted? Do we have?
If there is any judicial precedent in this Nigeria that a grandfather has requested for a DNA and it was not granted.
Yes, do we have?
I don't know any of, and I also do not know anyone that has been granted.
No, don't worry. Don't worry. Do we have any such situation where a grandfather has requested for a DNA for in Nigeria?
I just responded.
No, don't worry. No, don't explain. If you know, you just answer yes, simple. Don't explain. I don't want explanation. Do we have any case in the Federal Republic of Nigeria where the grandfather, has ever requested for the DNA of the grandchild and it has not been granted?
I don't know of any case like that.
Okay, if we don't have any case like that, then where does your argument of saying that this man cannot be granted by the court, where does that argument come from? Based on what? On your legal knowledge on what or what?
Oh yeah. Papariano, I already stated here, and I mentioned that there are 5 grounds that I know.
Oh my God! Is it judicial precedence? What are you saying now? You are very wrong. You cannot base on your ground. It's up to the court and judicial precedence.
I am not saying based on my ground.
What is this guy saying?
You understand? I am talking based on the ground of the judicial process that I know.
You are very wrong. Nobody can say Baba cannot be granted.
You are wrong. You guys are wrong.
You are so wrong. Nobody can say this man cannot be granted because it has never been done in Nigeria before.
Why
you acting as it's been done in this country before? You are very wrong.
Wait now.
Don't ever say that again in your life.
Now.
What are you saying? You are speaking as if we are not nuts here. You think we are dogs here?
And Aristocrat has been able to enlighten people.
That is how you find a way to deceive people.
Baba Mohbad has no legal ground to get DNA.
You cannot say so. You can't
given by
so.
Any court based
Bro,
on
you are so stupid. Just get out. Get out.
Stop moving. Stop moving.
Everyone, no, just wait. Aristocrat, okay? Don't play to this guy's game. Whenever you speak with him, be as corny as anything. He's so stupid. Okay? Don't let him come make people stupid here. And some of you, I don't know when you guys speak to him, you always like to agree with him. I don't know why. Top movie should never be agreed with. Don't agree with top movie unless he agree with you. Okay? He's very wrong. When he's speaking to you right now, you guys are agreeing on something neutral. That it would have been better or beneficial if a judicial precedence was established on this case. That is, if a court judgment was established on this case. All of us believe
that
so.
was what I said.
Where does his argument? He is already arguing as if he has a judicial precedence that is making him act. You know,
but the question he asked me
cannot be granted.
The question he asked me was that,
but you know,
agreeing to do the DNA, is he a judicial precedent? And I said no. That was an agreement. But it will be good if there is a ruling on this that will put everything to rest.
We have said this thing before. We said, Aristotle, let me just make this, maybe because it just coming. We have consent judgment, okay? And then we have court judgment. This is not new. We talked about it, that what was done in this recently is consent judgment. This is a situation whereby the courts, okay, preside on the judge, on the court uses the settlement that was made. Just please wait. Where the court uses the judgment that was made, that was settled or that was reached between two parties outside the court, outside the legal procedure. That is two party went outside the court and they have the agreement, and then the court ruled it. So they are binded. Exactly, they are binded. Please wait. Aristotle, please wait. A consent judgment is a judgment which the court adopts on behalf of two parties, which two parties has reached outside the court. Okay, that's a consent judgment. Why a court judgment is when two parties go into trial, they fight head to head. Okay, and then the judge decides. The judge decides upon the case. So a particular any court trial in which the courts had to decide the winner of the case, that particular case is a judicial precedence. Okay, simple.
That was what I said now.
Exactly, but the one that is consent judgment, it is when two parties, it is only limited. It is only limited to that two parties. Exactly.
And it's limited to that very case.
Exactly, to that very case. That's what we have been saying since. Tomorrow. There is nothing there is nothing here. He's the one that is deceiving himself. He just want to find a way in which he can make people look like they are stupid, like they don't understand, like there is anything special about whatever he's saying. I mean, it's so stupid. I don't like when people agree with him. No one should be agreeing with him. I won't like. No matter what top movie, it doesn't have any sense. Nobody should ever agree with him. I will never let that happen. It's so stupid.
The question he asked me.
Are we stupid here? Common consent judgment is making look like we don't know what is consent judgment and court judgment. There are consent judgment and we have court judgment. This case never went to trial. This is consent judgment. But what I don't want any of them to be saying. No, the father, top movie papa, they no born and where. Make it say, Baba Mohbad no get legal grant. Okay, nobody can say it because you're not the judge. And we don't have any reference that we can use to this particular case. I didn't we have reference before, where the grandfather has requested before and is rejected. You can say like that. You can say so. But we don't have any such reference. So where's your knowledge coming from that this man doesn't have the legal grant, that it will not be granted? Where is that coming from? Nobody can say. We have to wait until we can establish one in the history of Nigeria. Simple thing that this guy doesn't know. Okay? Nobody should say so. We don't have such case. And it's simple as that. They don't get themselves educated. They go around lying that the man doesn't have the legal guy, doesn't have the legal grant. Then why did women negotiate it? If the man couldn't get granted, why did women resort to negotiation? If I was women, I would have been stubborn. I would say, no, I will never negotiate. I will never negotiate because this man doesn't have the legal grant. Why did he negotiate? I thought she wanted to win the case. She has a very good lawyer that understands I don't know whether it's Falana or not Falana. You first stand for the case now. I've been now I get caught. Anyway, so let's move on from there.
Okay. All right. So can I make my submission now,
Yeah.
Mr. Papariano? All right. Good day, everyone. I mean, actually came up for Top Movie. Top Movie. I don't think you know what you're saying. I don't really think you understand the implications of the things that you come up to say without concrete evidence. And some of the things that you say is actually disturbing to listen to you. So just to buttress what Mr. Papariano had just said, does Mr. Lubaba have the right to ask for a DNA? 100% yes, he does. So the question is, when Mohbad was alive,
that's too close. He has the right to ask, yes, but can it be granted? Nobody knows. That's the right answer. Nobody knows.
Exactly.
There is nothing like legal grant or no legal grant. Nobody knows. There is no judicial precedence and there is no direct law. So don't play people around.
Exactly. Very, very true. So now let's move past that. And he said something that made me actually, come up to your platform this morning. And he says something, I'm not sure, I cannot really put words to words from what he says, so I don't want to, misquote him, but I'm just going to paraphrase it. So now you said that if Mohbad was alive and Mohbad, agreed to, to the child, even if the child was not his, then that is a legal ground. So the point is that when Mohbad was alive, do you have a concrete evidence that Mohbad consented to that child? Do you have a concrete evidence from that? So if you have a concrete evidence that Mohbad actually accepted that child when he was alive, that's a different case entirely. But if you don't have a proof that Mohbad, when he was alive, actually accepted that child, I don't know how you can debate that. I don't really know how you can debate that. And that is why they are asking this young lady to go have a DNA. And having a DNA is not a crime. Doing a DNA is not a suicide. It's not on a suicide mission. The father of this child, the grandfather, can contest the paternity of a child. So just like Papariano said, it now depends on the court to either grant that or not to grant it. They have the right. And you coming on platforms and deceiving people is very, very irrational. And it's very debilitating, if I can use that word. Nobody is questioning the paternity of the child because actually, just like Mr. Aristocrat said, as long as the court hasn't given a verdict yet, we cannot actually say that the child is not Mohbad's. We can't say that because we don't have a proof. And the proof is DNA, and we don't have that at hand. And if we go around to say that the child is not Mohbad's, it's not, and I think we are doing ourselves injustice because it hasn't been proven yet. Until the court have a stamp on it, then we can go ahead to say that. So Top Movie, you need to be mindful of the kind of things that you come to platforms to say because you are deceiving people. Thank you.